But without further ado, I want to introduce the Rhode Island Attorney General, Peter Nerona. Thank you so much for being with us today to address such an important topic, student loans.
Well, thanks, guys. I'm really glad to be with you. And I really want to thank the AFL-CIO, which is doing so much for working men and women, particularly in these days of uncertainty with what's going on in Washington. And the new administration is doing things that, frankly, are creating great uncertainty at best. So thanks for all that you're doing. I know our topic today is student loans, and I know that landscape has been constantly changing over the last several years. As someone, and first of all, let me apologize for not being in my normal suit uniform. I had a little medical procedure this morning, and so I came home afterwards. But I had student loans myself when I went to college and law school, and things were simpler back then in a way. I mean, we paid them. But the interest rates were really low, and tuition wasn't anywhere near what it was today. And but I know what it's like to have loans, and I know what it's like to have to spend a number of years paying them off. And frankly, in my case, taking a job I didn't really want at a really large law firm because it paid better, and served me better than I thought it would, but I couldn't do the kind of public service I've been doing for the last 30 years, because I had that obligation. So, the uncertainty is something that is a challenge, separate and apart from the obligation. And then there are these companies out there that even before, well before Donald Trump and well before COVID, were taking advantage of student loan borrowers. They frankly were predatory and were not following their obligations. And I remember then Treasurer Magaziner and I working with our friends in labor like the AFL-CIO to put together legislation to push back on some of that predatory behavior. And we have not been asleep at the switch since then. But I know that today will be a good opportunity to kind of refresh all ourselves as to what the state of the law is, what the current challenges are, where people with student loans can go when they need a resource or they need help, which is certainly our office. Alex Carvevale on our staff will be presenting, and Alex is a terrific lawyer that is doing just amazing consumer work all across the board in our office, but it includes work on student loans. So really encourage you to reach out to the office. We are here to help. I believe that we are the people's lawyers. I've always felt that way. Feel it particularly acutely now as we push back against the Trump administration and their policies. But going beyond, this president has come, he will go. But you young people, and particularly young people on this Zoom, will be Americans and workers and contributors and citizens for a long time. And so that's where I find hope. And I hope that today we will be able to put you in a position to help you. And just know that we are there to help you at the office. All we are is a phone call or email away. So I would encourage you to reach out to us. And I want to thank the AFL-CIO for having me today.
Fantastic. Thank you. And I think that is a great segue then to our presentation with Alex Carvevale, who hopefully will help us get a more zoomed out perspective of the legal landscape here with student loans.
Autumn, thank you so much. And I'm so happy to be here today. So as Autumn mentioned, my name is Alex Carvevale, and I'm an attorney in the Consumer and Economic Justice Unit in the Civil Division of the Rhode Island Attorney General's Office. I want to start by echoing what General Nerona said. Our office really tries to be responsive to consumers who are having an issue with their student loan servicer or their debt holder. If you think that your student loan servicer or debt holder is doing something illegal, you can call our office and we'll try to get to the bottom of it. And we want to be helpful where we can. And sometimes that's just giving information or directing people to the right resources. And I'm also so glad to be here today presenting with Betsy Mayotte. Individuals like Betsy and her team are irreplaceable in terms of providing great access to information for student loan borrowers. They do fantastic work. And I'm also grateful to Autumn, Haley, and all the organizers of this meeting for allowing me to talk today a little bit about the broader legal landscape, which is what I'm going to focus on. Let me just move a slide here. This is such a difficult time to be a person with either federal or private student loans. During the past 6 years, borrowers have had to deal with the constant specter of a word you're going to hear a number of times today, and that's uncertainty. During the Biden administration, the questions were often, what is the current administration's plan for student loan forgiveness? When is that plan going to go into effect? Maybe will I qualify for expanded student loan forgiveness? And then eventually the question was, will a court strike down extending public student loan forgiveness? So I want to talk a little bit about how we got here and the decision in the case Biden v. Nebraska, which was the early case where six states challenged the Biden administration's plan to provide expanded student loan relief. There were some questions that were raised during the pandemic in terms of the impact on student loan borrowers that we've never really answered. I think some of those questions are, how are we going to treat borrowers who had payments paused for longer periods of time? Was the government going to make any changes that would forgive debt or offer other pathways to debt forgiveness? And I think we'd probably be grateful for those same challenges today. To say something really positive about the Biden administration, this was a priority for them, and they did pursue it. So as we see on the slide, student loans were paused, through the pandemic, or at least through, part of the pandemic. And then President Biden announced his plan, in August of 2022. And I think the reaction to that plan, there was some divided reaction. And I think some advocates looked at it as, did the plan go far enough? Because it was fairly limited and it offered a certain amount of debt relief to borrowers, but it wasn't an enormous amount. It was a modest plan, I thought. And then other observers worried that the justification for the plan that was proposed by the Biden administration, that it wouldn't get past the Supreme Court, and that fear did prove to be true. So the Supreme Court decided Biden v. Nebraska, and the conservative justices voted to strike down the plan. I think what I want to say about the Biden v. Nebraska decision is that there's probably like a silver lining to it. I'll start with that, because I think there's a part of this Biden v. Nebraska decision where the conservative Supreme Court was articulating that executive orders only had so much power and that Congress had to act. And the majority opinion of the conservative justices in that case was that the Secretary of Education was not allowed to rewrite the intent of Congress to the extent of the $430 billion that it would have taken to forgive those student loans, that student loan debt. And the majority opinion in Biden v. Nebraska ends with a really interesting section where it addresses the concern of the liberal dissenting justices who may have suggested in their dissent that this decision was politically motivated against the Biden administration. And I think I would encourage you, if you're interested in reading Supreme Court opinions, and I enjoy reading them because I think we do have writers on the Supreme Court who are terrific writers, and they're really able to explain complicated legal concepts to lay people. And I think they write their opinions with an eye to that. And I think that's a trend that's kind of been happening over time. So I encourage you to read what they wrote. And here it was Justice Kagan who dissented. And the first thing she said that she didn't think, and the liberal justices didn't think, that the 6 states who challenged the Biden administration plan had standing to bring claims. So some of you on the call may be familiar with the legal doctrine of standing. It basically just refers to the theory that only some individuals are able to bring claims in court, and that you can really only have standing to bring a claim when you've been harmed by the conduct, when the injuries that you've suffered have a causal connection to the conduct, and when the claims that you have can be redressed or basically addressed by the court. So Justice Kagan wrote that Missouri and the other states, I think you can see the full list of the states who joined this specific lawsuit on the slide here. Justice Kagan said wouldn't really have been impacted by the student loan debt forgiveness plan that the Biden administration offered, and that the real party that was harmed was the quasi-government entity that's involved here, known as MOHELA. And I know that there may be people on the call who have loans that are serviced by MOHELA. MOHELA is an instrumentality of the state of Missouri, and it was created by the Missouri state government, and it owns hundreds and hundreds of thousands of loans. It services around 2.75 million loans. It purchases student loans. It sues borrowers to collect on student loans. And what Justice Kagan pointed out in her dissent was that MOHELA was not the plaintiff in this case, and that MOHELA actually actively resisted cooperation with the Attorney General's office in Missouri because they didn't want to be a plaintiff in this case. I don't know exactly why that was the case, but Justice Kagan pointed out that MOHELA would have been the real party in interest. They would have been a plaintiff who would have been harmed by this because they own the student loan portfolio. And she thought that they were required to bring this suit. But of course, she voiced that in dissent. A question that's really often asked coming out of this is like, was the Biden administration wrong to sort of put forward this plan and the rationale? And, I think in the wake of the decision in Biden v. Nebraska, let me go back to this slide. In the wake of the decision in Biden v. Nebraska, they tried to reformulate the plan. So the basis of the justification that they sought to expand the Secretary of Education's authority to provide this student loan forgiveness was something called the HEROES Act, which was basically an act that allowed the Secretary of Education to suspend student loan payments in times of emergency. So the Biden administration cited the pandemic as the emergency in question, and I think by the time that Biden v. Nebraska was decided, we were in what the Biden administration would probably have considered the latter stages of the pandemic. And I think they announced fairly early on in their administration that the pandemic was over. And so it may have seemed to some of the conservative justices that it was tough to claim that the emergency was still ongoing, regardless of what you think of whether we were still in the pandemic or whether we're still in one now. I think the issue is that the justices said, well, you're saying publicly that the pandemic's over, but now you're using this as the justification, right, for student loan forgiveness. And so I think when the Biden administration got this decision, they sort of went back to the drawing board, and what resulted essentially was, other litigation and other decisions by the Supreme Court. I think we all know the plan hasn't gone forward. It never went forward. And then Trump took office. So I want to turn to some of the changes, that we've all experienced this year and talk about a little bit about what the impact on student loans may be. And before I do that, I think one thing that Betsy and I were talking about a little bit before we started the presentation today was that, this is that word again, uncertainty. It's a very chaotic time. And I'm so curious today what Betsy's going to say sort of about what she thinks, the unfolding landscape is going to look like for borrowers. And so I think whatever we say today, we know that could change very quickly, right? We all read the news and we're all deluged by what we read in the news. And, it doesn't matter how much education you have or how much you know about what's going on. This is complicated stuff, right? So that is doubly true of borrowers. If experts don't fully know like what the impact of the Trump administration on their student loans is going to be, how can borrowers be expected to kind of make decisions based on what they hear and they read in the news? So I'm very cautious of that. So I think I want to talk a little bit about the changes that we do know about and speculate on those that we don't. So we know that President Trump took his oath of office in January, and we know that whether the whether they were actually authorized by the president or not, that Elon Musk's Doge Group has been going from agency to agency, and they've been, according to them, making cuts or providing efficiencies. And what that looks like practically, at least in the Department of Education and in most other agencies that we know about, right? It's been mass firings, it's been mass dismantling of the administrative functions. And it's been, probably not a surprise to people who were aware of some of the plans that this administration had, before they took office. And it's all sort of laid out in the document that they have, and they've vowed to destroy the Department of Education, and they've started doing it. So we know that wrestling billionaire Linda McMahon was confirmed by the Senate as the Secretary of Education in March. She had served with the Trump administration and the prior administration. I think she was brought in for a specific purpose, right? To fire employees, to destroy the department, and to shift functions of the department to other agencies, which we'll talk about in a second. Okay, I'm going to start moving a little more quickly, just being conscious of the time. So, on March 7th, President Trump issued his executive order restoring public service loan forgiveness. And I'm not going to, I wouldn't want to force anyone to read the entire order, but I do want to read a little bit from it. So the executive order that President Trump issued on March 7th says that the public student loan forgiveness program has misdirected tax dollars into activist organizations that not only fail to serve the public interest, but actually harm our national security and American values, sometimes through criminal means. The executive order then states that the public student loan forgiveness program creates perverse incentives that can increase the cost of tuition, can load students in low-need majors with unsustainable debt, and may push students into organizations that hide under the umbrella of a nonprofit designation and degrade our national interests, thus requiring additional federal funding to correct the negative societal effects caused by these organizations' federally subsidized wrongdoing. So I think my initial takeaway, when this executive order came out, is that this is a kind of viewpoint discrimination, which states that those individuals who have views that the Trump administration finds unpalatable could be ruled ineligible for student loan forgiveness, right? And I think we've seen in corresponding stories in the news that the Trump administration is focused on suppressing the voices of various students. Their framing is that it's a national security issue. I think, opponents have stated that that's a pretext, and that is the kind of just the viewpoint discrimination that I've mentioned. And maybe there's other goals, I don't truly know. But I think the thing that we can all sort of maybe agree on is that once Trump issued this order on March 7th, that if borrowers were made anxious by the idea that student loan forgiveness might not come to pass or help them, in their unique situation, this new kind of era of student loans offers even less, again, that word certainty. Let's move on from this slide. So just talking a little bit in this slide about what the impact on borrowers may be, from the Trump administration's moves with dismantling the Department of Education. So we know that online applications for income-driven repayment plans reopened on Wednesday. The department had told borrowers that paper applications were still being accepted. I think this is a signal, and there's never been any signal otherwise, that the Trump administration does intend to have some agency within its administration maintaining student loans, providing some kind of resources to borrowers who have federal student loans. I think these Republican states, fought to preserve these obligations. And, I'd be surprised if the Trump administration, I don't truly know, if they didn't view this as an asset. They want to recover on these loans, and the dismantling of the education department has very little to do with that. I think we have to view this in context, right? Because the Trump administration is putting a ton of pressure on academic institutions. They're threatening to withhold federal funding. Some institutions like Columbia have reached accommodation with the Trump administration. Other institutions have signaled that they're more likely to fight back. I think there was some news regarding that the University of Michigan intends to abolish certain programs that were criticized by the Trump administration. So the news about this is flying fast and furious. But I think there's a targeting of education here and of the institution of higher education that we need to be mindful of when we think about how that could sort of impact student loan borrowers. All right, I want to move on from current events, and I can't wait to hear what Betsy has to say about them. The last point I want to make on current events, though, is that, and I'll let Betsy talk more about this, is that the Trump administration has mentioned that they may move the student loan administration function of the Department of Education to the Small Business Administration. And Kelly Loeffler, who heads the Small Business Administration, had posted, on X.com that she was ready and willing to take up that challenge. I think it kind of shows to me just that there's this public back and forth over it, that there's probably not been a decision made, and there's no like firm plan that borrowers can rely on. Obviously the fact that loans were transferred to, if loans do get transferred to the Small Business Administration, we don't know if that will change anything for borrowers. It probably, wouldn't, but we'd just be speculating. So yeah, we all know that we're in a time that's very difficult in terms of news is being made every day that's going to change, what the obligations of borrowers are going to make, and news is being made that's going to affect all of our lives. So mindful of that chaos, I think I want to kind of take a high level view of what can borrowers do today or in the future, and how should they approach navigating their own federal or private student loans. And for the most part, I'm going to leave the discussion of the federal student loans to Betsy, because I know she's far more knowledgeable about that than I. But the first thing, when someone tries to collect any debt from you, the first thing you want to do is kind of get all the information about the debt that they're trying to collect. And so a debt validation request is a very powerful tool. It can be done under federal law. And through requesting debt validation from your debt holder, you're going to get a lot of great information about your debt. You're going to get a statement about who's collecting your debt, like what the entity actually is that owns your debt may have changed. You're going to get a ton of information about the account that purportedly owns the debt, the amount that's due, information you can use to reply to the collector. This is all great information, and you're making your debt holder provide information to you as opposed to just collecting. And while during the 30 days that they have to provide you this information, they can't collect your debt. So file a debt validation request. All right, moving more quickly. So I want to talk about default and bankruptcy really quickly here before I turn it over to Betsy. So debt holders do have maybe more options than they think. I think it's hard to give general advice on this to student loan borrowers, because every loan or set of loans can be different. If you have private student loans, your decisions are going to be very different than if you have federal loans. And I think that if you have private student loans, or if you owe a lot in debt, you have to think to yourself, like, am I ever going to be able to pay off my loan? Is it going to require more than I have, or am I ever likely to earn? And then you're going to want to act on that basis. So I think I'll move on to our bankruptcy slide really quickly here. So bankruptcy is a really powerful tool. A lot of borrowers will get a fresh start in bankruptcy. You can qualify for certain forgiveness under undue hardship. We're coming up where we have a generation that is probably unlikely going to be able to own their own home, in the first 10 years of their adulthood. A lot of folks are not going to have that appreciable assets. They may just have debt. Bankruptcy is a great tool. It can reduce and eliminate debt. It does that regularly for businesses, right? Businesses know the power of bankruptcy, and individuals should too. So I have on this slide chapter 20. You can file a chapter 7 bankruptcy, and then you file the chapter 11 after that. There's lots of powerful tools. I don't practice in bankruptcy law, but I know we have in every state, there are a ton of great bankruptcy law practitioners that can help individuals. Sometimes the cost of hiring a bankruptcy attorney could be a lot less than you expect, and you could benefit greatly from filing for bankruptcy. Um, I want to end by just thanking all of the nonprofits, and I know there's attorneys out there and there's non-attorneys both, who do an amazing job of providing accurate information. I think what I would impress upon student loan borrowers in terms of what their steps should be and how they should think about their student loans is pick a specific strategy, right? If you're going to pay off your loans, try to pay the least amount you can as soon as you can so you get it behind you. If you know that you're unable to pay, focus on the lowest monthly payment or consider other options like default or bankruptcy. And use the resources. So I highlighted one creator who I follow. I think she does a great job. Her name is Natalie Jean Baptiste. She's an attorney who has some great YouTube videos and TikToks. We need to connect with people where they get their information. And I think folks like Betsy and Natalie, they do such a great job of that. And I hope, as I mentioned at the beginning of my presentation, that you'll contact our office or you'll refer people who contact you to contact our office. If they think that their debt holder is trying to collect that illegally, call us. If you just have questions like who's the best person to talk to about this, what's like a verifiable, reliable resource, because there can be misinformation out there, right? Take advantage of these resources. We have such an amazing community of people who are out there to help borrowers, and I want borrowers to know that. And then the last thing I have on here before I turn it over to Betsy is the waiting game. Not to hammer home this point about the chaos that's going on right now, but to some extent it has to exhaust itself out of necessity. And we're fighting back. Our office is fighting back if we think the Trump administration is doing something illegal, or if they're withholding federal funding and they don't have a reason to do so, or if they're doing more nefarious things than that. We're paying attention, and I know we're not the only ones. And I think I would absolutely stress what General Noronha said at the beginning. In 4 years, borrowers will still have student loans, and hopefully we'll still have free and fair elections. And if that happens, then we're going to see a different landscape than there is now. So if there's a particular borrower who says to themselves, I need to wait to figure out what I'm going to do, I'd say that makes sense to me. And I want to end just by thanking everyone for having me here and saying, call me again if you have questions or issues. Thanks so much.
Thank you. That was such great information, really dense. I know that I'll probably going back on your presentation and watch pieces of it again to make sure that I got it right. And that's why we record these things, to be a resource for folks moving forward. And now I'm also really excited to segue to Betsy Mayotte's Betsy Mayotte's presentation to give us more perspectives on borrowers' options. So thank you so much for being here, Betsy.
Thanks for having me, and thank you, Alex. I hope you and I get to connect offline because I think you and I are going to nerd out on this stuff. Let me pull my slides up. So listen, just to give you a warning, I tried really hard to cram like 7 hours of material into 7 minutes. And I don't know how good a job I did. So just again, to set expectations, my job here this morning is, or this afternoon, is to give you a very high level overview of the options that are available to student loan borrowers. Unfortunately, we won't have time to go into the gory details of the eligibility, but I love doing that. So maybe we can do that in the future. And then if there's time, I'm sort of going to prognosticate a little bit about sort of the effects of the reduction in force. And as well, I'm actually really closely watching Congress and the Budget Reconciliation Act and how that could affect both current and future student loans. So just really quick, the name of my organization has been batted around a few times. For those of you who aren't familiar with it, the Institute of Student Loan Advisors is a nonprofit that I founded back in 2018. I've been in the student loan space in a compliance or advocacy role since the earth cooled. And I came to the realization that there was a real need for a neutral party to offer free student loan advice to consumers, expert student loan advice, someone that had no connection to the loan whatsoever. So I founded TISLA, like I said, in 2018, and our volume has been growing since the moment we opened our virtual doors. So anybody can reach out to us via email, and we answer most emails within a business day. And whether they just need everyday student loan management advice, or we even help with some dispute resolution. We don't collect people's information. We don't accept advertisements because we want to make sure that people know that we are neutral. So also our website has a lot of what I'd like to think is plain English information about student loans. If you look at it now, like I'm a little embarrassed, sort of like you showed up unannounced and my kitchen was dirty. We are in the middle of a website refresh. So come back in a couple weeks and it'll look like a 2025 website instead of 2018 called and wants their website back. And hopefully it'll be a little bit easier to navigate as well. So I know I'm talking really fast, but again, I want to try to cram as much information into my time as I can. So I want to just really quickly do an overview about public service loan forgiveness. That's by far, I think, the most well-known forgiveness program. And so far, well over 1 million people have received forgiveness of their remaining balance, including interest on their federal student loans. Gets kind of a bad rap that it's difficult to navigate, but it actually isn't. A lot of those data points you see where only 1% of people get approved, I call that a factual myth, because the data point at the time was accurate. But if you looked behind the data, the truth of the matter was most of the people that had been denied hadn't even been in repayment long enough to have gotten the 120 eligible payments they were required to have to get PSLF. Those numbers are increasing really quickly. I see people achieve PSLF every single day. As recently as this morning, a TISLA borrower sent us a really happy email. Part of that is because, look, people have now been in repayment long enough to get PSLF, but also because the Biden administration took away a lot of the more like bureaucratic, like why type of rules to make it easier for people to achieve PSLF. But if you're not familiar with the program, in order to get the balance of your federal student loans forgiven for PSLF, you have to make 120 eligible payments on an eligible loan while working for an eligible employer. And I set it up this way on purpose because if you remember this slide and nothing else, you're going to be able to answer 85% of the questions you'll ever have about PSLF. Because the key here is in order for a month to count for PSLF, all three of these things have to happen at exactly the same time. You have to have made an eligible payment on an eligible loan while working eligible employment. And I'm going to define all those eligibles in the next slide. So for example, you could be making an eligible payment on an eligible loan, but if you're not working eligible employment, that payment's never going to count. And you can, mix and match those and the answer is going to be the same. So again, if you're trying to get like a decent grasp about PSLF, this is the slide you want to remember. Now, really quick, defining all the eligibles. What you're going to see if you start digging into student loans is that there's almost always a short answer and a long answer. Today, I only have time to give you the short answers. But an eligible loan is any federal direct loan. That can be a Stafford loan, Graduate Plus, Parent Plus, or Consolidation. Doesn't matter when the loan was made. They made the very first direct loan back in 1994. If you have a vintage 1994 direct loan, it is just as potentially eligible for PSLF as a bright and shiny new 2025 direct loan. There are other loans that can be consolidated to make them eligible, but you'd have to consolidate them into the direct loan program. Eligible employment. This is where a lot of the myths exist for PSLF. It actually doesn't matter what you do for a living at all. What matters is who you work for. If you're working at least 30 hours a week for any government employer, federal, state, local, or tribal, any 501c3 nonprofit, and in some situations, although there's a few more boxes you have to check, other nonprofits that aren't 501c3s can also be considered qualifying employers for PSLF. Now, I just want to hammer home the fact that it doesn't matter what you do for a living. So the example I like to use is, let's say we're talking about the Providence public school system. My guess is that if you polled the teachers that worked for the Providence public school system that had student loans, they'd all know that they're potentially eligible for PSLF, and they are. But so are the cafeteria workers, the groundkeepers, the principals, the administrative assistants, anybody who is a direct employee of the Providence public school system is just as potentially eligible for PSLF as the teachers are. Now, an eligible payment is a payment that's made either under a 10-year standard plan, but that's kind of a trick. Because if you make 120 payments on a 10-year standard plan, you're going to pay your loan off, most likely. So most people, although the COVID pause gave people like 4 years of credit, but especially people just starting their PSLF journey, most people really need to get on an income-driven plan to benefit from PSLF. And all the income-driven plans count for PSLF, assuming you're checking the other boxes. It's an eligible loan. You're making that eligible payment on an eligible loan while working eligible employment. So, speaking of repayment plans, let's talk about them a little bit. So, currently in the federal student loan programs, we have an embarrassment of riches as far as the sheer number of repayment plans available to student loan borrowers. And there's so many of them that it actually is now starting to cause a lot of confusion. And I think we can expect in the future the number of plans to be pared down. But as of today, there's the plans, they basically fall into two buckets. There's the bucket of plans where the payment is based exclusively off of how much you owe, the term of your loan, and your interest rate. So two people that owe $100,000 in federal student loans, maybe one of them makes $25,000 a year and the other one makes $200,000 a year. They're going to have the exact same monthly payment amount if they're under one of these non-income driven plans. There's no forgiveness component to these plans. The payment can change for example, if you have an older loan with a variable interest rate, or if you pause your payments for a period of time due to forbearance or deferment, that can alter the payment a little bit. They all have payment minimums, depending on what you owe. Most of the minimums are either $30 a month or $50 a month, and they don't require renewal. Once you're in them, unless you actively change the plan, you're going to stay in them until your loan's paid in full. Now, in general, and of course, there's some exceptions to this, in general, the non-income driven plans don't count for PSLF, but I can't say the words in general enough. There's so many asterisks and footnotes to that statement. But again, if you're pursuing PSLF, most people are really going to need to get on an income-driven plan. Income-driven plans, payments are based on income, shocker. There is maybe some of that is up for grabs because of the SAVE litigation, a forgiveness component baked into those plans after either 20 or 25 years on the plans. The payments don't change in general unless your income changes or unless you fail to recertify your income when you're required to. Not all loans are eligible for all income-driven plans, but every federal student loan borrower, whether they have a Stafford loan or a Grad Plus or a Parent Plus or a consolidation loan, is going to be eligible for at least one of the income-driven plans. They all, again, require annual renewal, and they all count towards public service loan forgiveness. Now, the non-income driven plans, they are the 10-year standard plan. For a lot of people, that's going to be your cheapest plan in the long run, assuming you're not pursuing and are going to benefit from a forgiveness program. The 10-year standard is going to have you paying the loan off the quickest with the least amount of interest. Extended repayment, it just basically extends your term to 25 years. Graduated repayment is sort of self-explanatory. You start off with interest-only payments, and then the payment bumps up every couple of years. Or you could mush together graduated and extended, where you have interest only for a couple of years, but they still extend the term to 25 years. Consolidation loans also get a standard repayment plan, but it's not a 10-year plan. It's between 12 and 30 years, depending on what the balance of the consolidation is. And consolidation loans are also eligible for graduated repayment. The income-driven plans, boy, they are all exactly the same except where they're different. In fact, as you'll see, two of them have exactly the same names, but completely different terms. So no wonder people get confused. So for the income-driven plans, we have old IBR. That's the old. Now, if you have some old loans, like pre-2010 loans that are under the FFEL program, Federal Family Education Loan Program, old IBR is the only plan that those FFEL loans can get that falls under the income-driven plans. That is based on 15% of your discretionary income. New IBR is only for direct loans and only for people whose entire loan history is post July 2014. They base that payments based on 10% of your discretionary income. Pay as you earn is the fraternal twin of IBR. The terms are exactly the same, except that you have to have no loans older than 2007 and at least one disbursement after 2011. And ICR is based on 20% of your discretionary income. There's an alternative calculation that is a whole other 20-minute presentation that's essentially based on the 12-year term of your loan. For most people, unless you're high income and low debt, ICR tends to be the highest of the income-driven plan amounts. All these plans cross-pollinate with each other as far as the forgiveness component that's baked in. Regarding that forgiveness component, right now, because of the SAVE litigation, the 20 and 25-year forgiveness component of pay as you earn and income contingent repayment is in question. The courts are saying that because Congress didn't spell out the word forgiveness in the statute under income contingent, that it's questionable whether the Department of Ed has the authority to give forgiveness. Now, those of us that have been around for a while are going, what? You're bringing this up now? Because ICR has been around since 1994 and no one's ever questioned the forgiveness component of it. So we're going to have to wait and see what happens with that. IBR, old IBR in particular, has a 25-year forgiveness component. That is in statute. So that is not at risk. So there are, and people who might already be close to the forgiveness timeline for some of these other plans, one thing you can do is apply for IBR, and you're not going to have to restart your account. Again, all these plans sort of cross-pollinate with each other as far as the 20 and 25-year timeline goes. One thing I want to mention, Parent Plus loans, they're kind of mean about it, because Parent Plus loans, by the way, again, are eligible for PSLF, but at face value, they're not eligible for any of the income-driven plans, which, again, I think is mean. Parent Plus loans can consolidate, at which point they're eligible for ICR and ICR only. However, there's this thing that we used to call the super secret double consolidation loophole. It's not so super secret anymore, but it is overly complicated. But it's a way for Parent Plus borrowers to actually get access to these lower cost income-driven plans, such as IBR and new IBR and possibly pay as you earn. I don't have time to go into to explain how double consolidation works, other than to say that you're essentially consolidating each of your Parent Plus loans twice. I do have step-by-step instructions on that double consolidation loophole on the consolidation page of the TSLA website. Now, right now, there's a deadline under the regulations for that loophole of July 1st. However, the current injunction on the SAVE litigation makes that deadline go away. So that deadline could come back depending on how the court case shakes out, but it also might not. So for those of you who go to our website and go, I don't have time to get this done by July 1st, you actually might have time, even if that deadline remains. But again, the deadline doesn't exist at this particular moment and may not come back. So it might be worth a shot. Okay, another really popular program that we get a lot of questions about from borrowers is called teacher loan forgiveness. And teacher loan forgiveness is for people who have no loans prior to October of 1998. You can have either FFEL or direct loans. It only applies to Stafford loans. And you have to teach in a Title I school, which is generally a school that has a high percentage of students that qualify for free lunch. And once you work 5 consecutive years for a Title I school, it can be, you can switch schools. It just has to be a consecutive 5 years. You can get either $5,000 or, if you're considered a highly qualified teacher, $17,500 forgiven from your loan. Now, one thing that's important to note, the 5 years you spend teaching to get TLF cannot also be used towards the 10 years you need for PSLF. So in general, you're going to want to pick a program. For people who have a fairly low amount in student debt, teacher loan forgiveness is probably going to be your path. If you have a higher amount of student debt, PSLF is probably going to be your path. Now, there's a bunch of other discharges and forgiveness programs available to federal student loan borrowers. You can get your loans discharged if you should pass away, or if, in the case of a Parent Plus loan, if the borrower or the student for whom the loan was made passes away, if the borrower becomes totally and permanently disabled, if the school committed fraud, or if the school closed before you were able to complete your degree and you weren't able to transfer your credits, ID theft. ID theft can be difficult, but it is possible to get the loans discharged for that. And if you don't have the, quote, ability to benefit from your degree. Now, let me be clear what that means. Ability to benefit falls under 2 categories. Either you didn't have a high school diploma or equivalent and the school knew it and gave you loans anyway, and you didn't already have college credits under your belt, or you were in a degree program that because of something that is going on with you, state law would prohibit you from ever working in that profession. Let me give you the real life example of why that discharge exists. Back in the 80s, there was a truck driving school called Andover Truck Driving School, and they literally were admitting people who were legally blind and making them take out student loans. Now, someone who's legally blind can never be a truck driver by state law. So that's an example. Another example might be if you're getting a degree in early childhood education and you have some sort of felony on your record and state law prohibits someone with a felony from working with children. That's another example. What's not an example is I went to school for engineering and I ended up being a teacher, so I didn't use my degree because I decided I hated engineering. That's not an ability to benefit claim. There's also over 100 other forgiveness programs. Most of them are state-based. Most of them are profession-based. We have a database under the resources page of our website that we update about twice a year with all the forgiveness programs we're aware of, including the other federal programs, such as the ones for the military. There's also quite a few under the health professions. If none of the lower payment options work for you, you need to do whatever you can not to default. I hear people say, I just can't afford it, so they can default me. If you can't afford your payment now, you're really not going to be able to afford it if you default. Remember, the income-driven plans, at worst, are 10% of less than your adjusted gross income. If you default on your federal student loan, they're going to garnish 15% of your gross. And they're going to add up to 24% in collection costs. And there's a bunch of other terrible and horrible things that can happen. So again, it's actually more expensive, both monthly and in the long run, to default on your loan than it is to not default on your loan. But if you can't afford your payment, can't afford your payment. Thankfully, there's other mechanisms to prevent default, such as deferments and forbearances. Both of them temporarily postpone your payments. And we have a list of all of those and their eligibility requirements on our website as well, and as does studentaid.gov. All right. I've got 5 minutes left. Haley and Autumn, what do you want me to do with that 5 minutes? You want me to shut up and answer questions? Or do you want me to go through the SAVE litigation and the RIF and Congress? Or
why don't we open it up to some questions? We'll stop.
I think so too. You're going to send presentations so people can read the stuff that I didn't get to.
Absolutely. So let me quickly just say thank you so much, Betsy, and thank you, Alex, for participating. We post the recordings of these lunch and learns to the Labor Vision YouTube page, so you can find us at Labor Vision RI, and you can also find it on our website, laborvisionri.org. So thank you so much for being here. And now, Haley, we can stop the recording.